Anyway, thanks everybody for coming. So my name is Rob. I did IPO. So we've been doing events in Silicon Valley for a number of years. We have multiple events every week from San Jose to San Francisco. So I'd like to highlight a few events that are coming up. So this Thursday, the 2nd of June, Demystifying Stock Options. That's at Samsung, just down the street. Brand new facility. It's going to be an exciting event. I hope you guys can make it. June the 8th, in this room, Building Apps from Idea to Release. And we have Alex Sipkin. That's going to be a great event, too. So I hope you guys can make that one. Further on down the line, June 22nd, Pillsbury Law Firm, latest innovations in IoT. And we're also going to have a big sort of mini expo. So if anyone has any products in the IoT space, let me know. It'll be a great opportunity to be seen. So anyway, all the events are on our website, ideaipo.com, so check it out for all the details. So we were launched officially February 1st, 2010. At that time, we had 0 members and 0 events on our calendar. At this stage, we have over 40,000 members with all our meetup groups in the Bay Area. We've completed over 1,552 events. It's a lot of events. So at this stage, by any standard, by any measure, we're the most active, most prolific startup event organization in Silicon Valley. Bar none. Some of you guys knew that was coming next, right? Anyway, I'm not bragging, okay? I'm just stating a fact. But we have a lot of partners that help us do what we do. Law firms, venture capital firms, angel investor groups, incubators, accelerators, colleges and universities, lots of players in the Silicon Valley startup ecosystem. Tonight, we're grateful to InnoWest for hosting us at this beautiful venue. We've held many, many events here, and we look forward to many, many more. They're a great partner, and we're honored and privileged to be collaborating with them. So I'd like to have Helena from InnoWest come up and say a few words. Let's hear it for Helena.
Thank you. Hi, everyone. My name is Helena Powell. I'm an entrepreneur in residence with InnoWest. What that means is that I work on my startup and help InnoWest with advice, guidance, and whatever they need, pretty much. So what is InnoWest? InnoWest is a co-working space and an incubator. If you work on your idea, if you start a startup, and you need a space to work at, which is probably better than your house, that's the place. You can get high-speed internet connection. You can get any amenities, pretty much, that a regular office will give you. But the advantage here is that you get the community and you get the resources that will help your startup move forward and hopefully raise funding as well, which we also help with. So if you guys want to know more about InnoWest, you can email team@innowest.org or come chat with me afterwards. Thank you.
A few of our other partners are here tonight. Let's hear it for Chrissy from Travantis.
Hi, just a quick word of what I do. I'm working for Travantis. We're a cybersecurity consulting firm in San Jose. We provide technical testing, vulnerability scanning on applications, network, web, email. So if you guys have any database changes in your network, come see me. I can talk to you about how you can secure your system in the cloud, whether it be your enterprise software applications or your database management. Thank you. That's about it.
Okay, another one of our partners, Mike from CTO 911.
Hi, I'm Mike. With CTO 911, I specialize in enterprise software development. I've been helping Silicon Valley entrepreneurs with their software development processes, prototyping, database system designs, troubleshooting, debugging their project team, figure out issues, setting up teams. So if you have anything related to technology that you need somebody to help you along the way, I basically sit along your side and help you get things done. Whatever is needed, and brainstorming, shooting ideas back and forth, I could do that. So come talk to me after the event or grab a card. I'll be happy to talk to you. Thank you.
Okay, so one of our missions is to support entrepreneurs locally in Silicon Valley. our greater mission is to democratize entrepreneurship globally. So to that end, we have a robust YouTube channel, youtube.com/ideaIPO. So we have tons of videos about all sorts of different topics, and we are recording tonight's event. So the idea is that whether you're in Palo Alto, Maui, or Timbuktu, you have access to the same great content that we have here tonight. Who's been to Maui? Cool. Who's been to Timbuktu? Not that many people. But there's Wi-Fi there, so anywhere there's Wi-Fi, you have access to all the tools you need to be a successful entrepreneur. So our partner in that endeavor is Tim Jeggers of Jeggers Films. Let's hear it for Chris.
Thanks, Rob. My name is Tim. Like he said, I do a lot of the video taping for the events. I've done a lot of the videos on the YouTube channel. I do photography as well. I like to tell stories through digital media. This is a little different, but I enjoy it too. You know, it's documenting things like conferences, seminars, and all of that. One thing that I want to ask all of you to do, big favor, for the sake of audio, when it comes down to questions, we like to hold them until the end. We're going to take this mic, move it in the middle. At that point, feel free to line up and then speak into the mic so that when the video is online, people know what the questions are and all of that. And yeah, I'm going to give it to Rob, and yeah.
Okay, so without further ado, I'm going to introduce our featured speaker tonight. Once again, he's going to speak till about roughly 8 o'clock. Ideally, hold your questions until the Q&A session, 8 to 8:30, speak into the mic. And believe me, it's going to go towards a long way when we have the video available on our site as far as it being a great learning resource. So thanks for your cooperation. So without further ado, Jason Putnam Gordon.
Let's get into it. So tonight we're going to focus on mergers and acquisitions, okay? And one of the reasons why I like to do this is many of you are probably first-time entrepreneurs, or maybe this is your second endeavor. But it's a good idea to have a roadmap or to see where you're going so that you can build a roadmap and actually get there. That's what we'll focus on today. So with that in mind, I like to always give, I wouldn't be a good lawyer if I didn't tell you that what we talk about today is not legal advice. We'll be talking about information about how mergers and acquisitions are done. We'll be talking about laws and rules. We'll be talking about exceptions to rules. We'll be talking about exceptions to exceptions, but they may or may not apply in your situation. So during this conversation, please do not take anything that we discuss as actual legal advice. That includes not only when I'm presenting, but also if we have questions and answers afterwards. Now, as Rob also mentioned, we're going to hold all questions to the end, but you'll probably see me throughout the presentation and hear me throughout the presentation indicate and try and get a feel to make sure you guys are understanding where we are and what we're doing. So, if you look lost, you can ask me to explain it a different way. We're not going to deviate and answer anybody's specific question, but I want to make sure that the folks who are here and then also the viewers who are on the video understand what it is that we're talking about. And it's very easy. I do this day in, day out for a living. It's very easy for me to understand these terms and understand these concepts. The rest of you are probably not as familiar as I am. Make sense? All right, let's jump into things. So what I first like to do is give you an overview of where we're going today. So first thing we're going to do is talk about background. We'll talk about my background. We'll talk about your background. We'll talk about the big picture, okay? Why it is that you would do a merger or acquisition, where it fits into the overall ecosystem and process here in Silicon Valley and business in general. We'll talk about the process, and we'll talk very extensively about that. And I have some slides that are a bit beastly, but we'll work together and we'll get through them. We'll talk about some common pitfalls, and then finally at the end, we'll take your questions and comments. So my background is that I'm a corporate and securities attorney. I've been practicing law since 2005. My law firm, I have a small boutique corporate law firm. We focus on the needs of emerging growth companies. So startups that are based here, but we also have startups that are in England, Australia, Asia, we work with a lot of startups. I'm licensed here in California, DC, New Jersey, Massachusetts, and Pennsylvania, but I only practice here. We love working with startups, and in my spare time, I jump out of planes. So if you guys are ever interested in skydiving, talk to me about that and after the questions section. So I'm going to ask you some questions. Who here is in a startup? Raise your hands. OK, most folks. Who here is thinking about entering or joining a startup? OK. And who here is a founder or co-founder? Who, for those folks who raised their hand earlier, who is this their first startup? OK, good. You got a lot to learn. Who here has received funding? And who here has had an exit? And who here has had a successful exit? That's good. That's good. Well, as I was chatting with some of you earlier today, entrepreneurship is a skill, right? And so that means you learn from your mistakes. You learn by doing. You also learn in a more academic setting, which is what this is. But if you keep trying at it, you'll get better and better. So that's the goal. So let's talk about the big picture here. And I always have this awful little graphic that I like to put up. But I think that it kind of reflects what startups are all about and what the sort of reason why you guys are doing this. So the goal is to increase the value in the company, right? And to eventually realize that value either by an IPO or potentially a merger and acquisition. We'll talk about that stuff shortly. But in order to do that, you're going to need inputs, right? You'll need the inputs of capital. Those will come from your investors. You'll need the inputs of ideas. They'll come from you. They'll come from the other folks who you hire. And then you'll need folks to implement those ideas. You'll need technicians, folks who have coding skills or marketing or business skills or accounting or legal. And all of those services and relationships get memorialized and put into the company. And the goal is to grow the company and have it become more and more valuable. Now, founders they may put in some money, but they also put in a tremendous amount of time. And at some point, you're going to want to be able to realize the return on your investment in time. Okay. How you do that is through either a merger and acquisition or an IPO. And the reason for that is that company stock, especially private companies, is illiquid. Who here has heard that term before? That means it's hard to change it into cash. It's not like it is shares in Google or Alphabet now or whatever, which you can freely trade on the exchange. So on the sell side, that's and it sounds like most of you folks are entrepreneurs. That's what you're sort of thinking about. Okay, you want to be able to realize the 3, 5, 10 years worth of efforts that you've put into the company. On the buy side, there are a lot of reasons to do this. And I was talking with someone earlier today, and they indicated, he had some experience because his previous startup was acquired, and they were the largest customer of that particular company. And there are reasons for doing it. So one is to expand into a new area. Another might be to pick up new technology, okay, or maybe a new customer base. So your competitor already has the set of customers, you like them, you want to be able to have them. That's called horizontal integration, and that's one good reason to purchase another company or the assets of that company. Vertical integration, that's the case where you have like a supplier, they're like your lone supplier, or they're your best supplier, and you want to be able to fold them into your company so you have control over the whole supply chain, or at least that portion of the process. And then the other reason sometimes that happens is, they're like private equity firms, and they see a company that they think can take it to the next level or needs to get restructured because there's certain issues, and they'll make a strategic investment because they think that company can be turned around and improved dramatically. So, in trying to decide between an IPO or a merger or acquisition, there's some things to keep in mind. And I think you'll see, and I don't know if you all are following this, but I follow it. M&A events are becoming much, much more common and much more valuable than IPO events. You probably have heard of the IPO window. Now, that's a period of time when it's good or favorable for a company to have an IPO. That window, it's a metaphor basically, opens and closes from time to time. Obviously, after the first tech bubble burst, in 2001 or so, the IPO window was shut. Before that, there were tons of startups going IPO all the time. It reopened for a while, then it closed for a while. And here are some numbers, which I pulled from just a recent Fortune article. In 2013, 50 tech companies had an IPO, and the events were worth roughly $12 billion. 2014, there were 60 companies, and 2015, there were 30. So you can see that number is going down. And as of the end of April of this year, only one tech company went public. Versus M&A events for tech companies, you can see that it's trending up. Okay, so it's more and more likely that in order for you to get liquidity, it'll be through a merger and acquisition or some sort of other change in control event. So let's talk about the process. And there are a few different routes or different types of transactions, and we'll sort of talk about all of them generally today. But you can do, who here's heard of like a statutory or a merger before? Nobody. Okay, that's cool. How about a stock purchase? Then how about like an asset purchase?
It's like a fire sale?
Well, it could be. It just sort of depends. Let's start maybe with one of the simpler ones. Let's talk about a stock purchase. So literally, let's think about that company for a second, right? That company has stockholders. Okay, they have shares of stock in that particular company. They're the owners. They elect the board of directors that make decisions for the company. And then the officers and employees carry out the decisions that the directors make. Okay. So a stock purchase basically is a mechanism by which someone will come in and want to acquire all of the stock that is outstanding. Sounds pretty good, right? I mean, there are reasons for doing that, which we'll talk about in a second. One of the problems with that is that in order to gain complete control or to own that company wholly, you need to go out and obtain the stock of each stockholder that exists. Okay. Oh, sure. Maybe if you've just started and it's just a couple of co-founders or 3 or 4 co-founders, that's pretty easy. Okay. But as companies develop, there'll be more folks who have stock or have the rights to acquire stock. Those could include employees or other investors. And so it becomes very difficult sometimes in order to acquire all of the stock in the company. The statutory merger is a mechanism by which you can basically, so long as you get a sufficient vote by both the board and by the shareholders, you can force the sale of all the shares of stock in that company. So it's a mechanism where you're able to sort of force that, not force in the sense that it doesn't want to be done, but it's the way around the problem of making sure that Bob isn't a holdout and seeking extra compensation for his shares or trying to be a pain in the butt. An asset purchase is that. Who here is familiar with the term asset? Right? I mean, those are basically things of value that the company has. They can be tangible, like automotive, like the company car. They can be intangible, like the intellectual property that you have. It could be goodwill. Could be your customer, supplier lists, things along those lines. An asset purchase is a transaction where certain of the assets and probably also the liabilities are acquired by the acquirer, and everything else is left behind. Okay, and there are reasons for doing that. And we'll talk about what some of the reasons are as we move through this. Actually, we can talk about some of these right now. So now we'll wait another second. So let's start talking about the process itself. Okay. So the preliminary process needs to start. Well, you need to have sort of the M&A idea sort of planted in somebody's mind, right? And there are a few ways that this can happen. So Perhaps, in the situation where you have a good relationship with your, either seller or supplier, somebody brings it up, it's like an unsolicited decision or even offer. They say, we like you guys, or we know you have this team of engineers that we want to hire. We'd like to potentially acquire your company. Or it could be more of a strategic decision, okay? As you run a company, it's the board of directors that makes the decisions for the company, and the board of directors should be meeting periodically. And so they should be assessing whether or not it is in the company's and the shareholders' best interest to sell the company, okay, to realize the value for the time and effort and money that they've put into the company this far. And that would be sort of more along the lines of the strategic decision-making process. Now, when that happens, there are normally some preliminary discussions, maybe some initial deliberations with the board, okay? And at that point in time, that's when you should be thinking about retaining some experts, okay? Lawyers is one set of experts that you're going to want to have as you're putting together a deal. Bankers are another really valuable source of information and a really important component to putting together a deal, depending upon the size of the deal. Accountants, okay, tax drives a lot of decisions, not all of them, but a lot of decisions. Understanding both those tax issues as well as depending upon who the acquirer or is, maybe some of the other accounting issues, right? If they're a public company, they're going to have to report their statements in GAAP, which is generally accepted accounting principles. Okay, you're going to need to know what the effect of the deal would be with that, and they would certainly need to do that. And strategic advisors, other strategic advisors, right? So maybe some other folks who are on your board or advisors on your board that work in that industry. These are people who kind of know about the market itself. Well, let's take that and put some concrete terms or some concrete sort of more concrete scenarios in there, okay? One of the reasons, or one of the strategic reasons that comes up from time to time to drive a sale of a company will be, let's say you have like a small startup, they've come up with a new or novel idea, okay? They've done pretty well, they've kind of demonstrated that they can get some traction. They have some customers, okay, but all of a sudden big competitors just join the fray and they can dump tons of money into that particular idea or that particular market, okay? Might be a good time to come out. You won't necessarily, it might be a good time to sell. You've already demonstrated process, or demonstrated that you have a market, you have like a real process there, but you won't be able to compete in the future. But maybe if you sell that company to one of the competitors, or to the competitor itself, there would be an opportunity for you to realize the maximum amount of value for your shareholders. Does this make sense? Yes. All right. Okay, good. You guys are alive. In that initial process, right, one of the reasons why you want to have, lawyers get involved earlier rather than later, and bankers and accountants, is that you're going to want to get an NDA or a confidential information sharing agreement in place. Okay, and why on earth would I want to do that? Well, there are many reasons. Okay, perhaps some of those reasons include, your customers. You don't want your customers to know or to think that you're going to go away, or that your competitors or suppliers know or think that you're going to go away. You could bruise those relationships, okay? There can be also other just sort of strategic and market reasons that you want to do that. From time to time, the buyers will want to propose maybe early on an exclusivity arrangement or agreement, okay? That is basically trying to lock you in so that if you sell the company, you can only sell to them, all right? And there are a host of reasons why you're going to want to have bankers involved with this and lawyers involved with it. One of the issues that comes up, especially in an exclusivity arrangement, is the following, okay? If you're on the board of directors or you have a board of directors, you have fiduciary duties to the companies and to the company's shareholders to maximize the value or the return for them, okay? You have to be very careful if you're going to enter into an exclusive relationship with a potential buyer that you're not selling the company for too little, okay? If the deal is big enough to warrant involvement by bankers, they will help you figure out what the company is worth, okay? And maybe help you shop it to other potential acquirers so you can realize more money for your investors, okay? Because you have a fiduciary duty to do that, and that means basically if you don't do it, potentially those directors are in breach of their duties and could be personally liable for those decisions. So this is important. Bankers help both on the buy and sell side, right? So sometimes there are bankers who will work for acquirers to help go out and find potential companies to acquire. They work on the sell side doing some of the things which I just mentioned. They're going to have an engagement agreement, okay? And if you have a savvy legal counsel, they're going to walk through the engagement agreement with the bankers, help to figure out some of the really common pitfalls and issues, which we'll talk about later, but those include bankers' compensation. They get 1% of the deal, 2% of the deal. How long is the tail on that deal? So for example, if they don't close in a certain window, is there a period of time where they will get compensation if you end up sort of basically selling the company anyway to somebody else, whether they introduced you or not? It's kind of like who here's bought or sold real estate? Okay, kind of like if you have your agreement with your real estate agent, right? If you sign that and there's an exclusivity provision in it, and they get a chunk of the deal regardless of how you find that buyer, maybe that doesn't work out in your favor if all of a sudden your cousin Bob says, look, I know you guys have been thinking about selling this house for a while, let's do the deal. So those kinds of things. You definitely want to have lawyers involved through the NDA process, okay? Some of the issues that come up in there that you want to also address, and I was mentioning to someone earlier tonight, is that you don't want the buyer to be poaching your team. So, this is a very common pitfall. We can talk about it a little bit more later. But those are types of provisions that get put in place there. The exclusivity arrangement, as I said before, can be a real pitfall to your board because they have fiduciary duties to maximize the value to the shareholders. And your lawyers will help advise you through that, and the bankers will help advise you through that process. So let's talk more about the actual process itself. Let's break it up kind of into the components, at least from the legal perspective. Okay, usually in one of these processes, as we do one of these deals, there's the first stage, which is called a letter of intent. It's also sometimes called a term sheet. We're going to walk through what some of the common provisions are in that in the next slide. There's the due diligence and negotiation of the definitive agreement stage. These two things kind of run in parallel. Okay, who here knows what diligence is? Yeah, it's looking into things, right? So that's an opportunity for the acquirer to take a look at, potentially, all the corporate books and records, all of the supplier agreements. Basically take that car and take it to an authorized mechanic and basically do a workup on it, Do we have, a Corvette with, a VW Bug engine in it, or is this the real McCoy? That can be very time intensive, and we'll talk about some of the pitfalls that come up there. But while that process is going on, there will be negotiation of the definitive agreement. Now, the definitive agreement can be a beast of an agreement. I mean, it could be 50, 100, 200 pages long. There are also side agreements and then also disclosure schedules that go along with that. So all of these documents get negotiated, and we'll talk about what goes into putting together a definitive agreement a little bit later. The next part of the sort of process is the actual signing of the definitive agreement. And then there's a period of time where basically it's like, who here sold a house? Right? You sign, and then you close. Okay, and in that period of time, there are some conditions to close that, get put into that agreement. You have to fix the radiator. I'm from Pennsylvania, so we have a lot of problems with like radon out there, and maybe you need to remediate the radon that's coming up through the basement of the house. So there are things that you may need to do to fix to get the company in shape so that the deal can actually close. And then there are post-closing items after closing. Closing is normally one of the happier days, I'd have to say, because people will be working for weeks or months to put this deal together, and then finally closing is when it actually comes together. Everybody opens up the champagne and has a good day. And then there are action items after that. So Now I'm going to move into my really thick and healthy slides. But we'll walk through each thing thoroughly. So who here has ever seen a term sheet or a letter of intent before? Good. So what you want to do with a letter of intent, or with a term sheet as it may be known, is to lay out and negotiate all of the significant terms of the deal. Okay? The reason for this is that if you were the seller, you have the most negotiation leverage at this point in time. Once you sign your letter of intent, or once you sign your term sheet, you, especially if there's an exclusivity period or exclusivity clause in there, that's it. You're already committed to go to the prom. Okay? So you don't get to go out necessarily and look for other suitors unless you're smart and you put in some provisions that allow you to kind of get out of it, maybe if a better offer comes along. Those are called fiduciary outs. We can talk about those later. So that's the purpose. Let's kind of dip our toes into what goes into this sausage. So generally they're non-binding. Okay, so that means they're generally not going to obligate you to some sort of contractual matter to proceed with the deal. Okay, usually each side wants the flexibility so that if things get uncovered in diligence, they can walk away, or if other circumstances change, they can walk away. That said, there are going to be binding, or there typically are binding provisions within them. Okay, those include the exclusivity period. Maybe a breakup fee. So if you decide to walk away, you got to pay some cash. Why would anyone want to do that? Well, because people will spend tens of thousands of dollars on this process, and there needs to be maybe not necessarily a penalty that's associated with it, but the risk of failure and it not proceeding, that gets negotiated just like many other risks throughout the deal. The confidentiality provisions will likely be, you'll either tag in another comp fee agreement, or you can lay it out in the letter of intent, but usually we'll see them refer to a separate confidentiality agreement or that NDA, which we would have already gotten in place earlier. Those things will be binding. Aside from that, though, even though it may be non-binding and not commit you to go forward, and you have to be careful that you don't inadvertently make it binding, but even though it may not be binding, you're going to be setting a psychological anchor. Okay, who here is familiar with that term? That means basically you're going to be already kind of setting up what people think is going to be normal in that deal or what people will expect. You'll be setting expectations. So you want to make sure you get this right. Now, you're going to choose the structure of the transaction. Earlier we talked about the sort of basics between an asset purchase, a merger, or a stock purchase agreement. And there are reasons for doing this, okay? Generally speaking, if you're an acquirer, okay, an asset purchase is a pretty good deal for you. Okay, you get a stepped-up basis on the assets from a tax perspective, and additionally, if you do it correctly, you're going to leave all these liabilities that might be a problem behind. Now, you have to be careful when you're doing this that you don't inadvertently pick up certain kinds of liabilities, but that can be really attractive. So when does that come up, or why would you want to do that? Well, so for example, we're working on a deal, and the acquirer, we're representing the acquirer in this situation. Okay, the target, that's the company that's being bought, or not necessarily the company, but the assets. They weren't good at keeping their corporate books and records. They didn't get great intellectual property assignment agreements and stuff in place, and there might be also some liability for violation of employment law issues with regard to how they ran. And this is very common with startups, right? Everybody runs out there, hires everyone as a consultant, regardless of whether or not they're actually a contractor or an employee. So they get that wrong all the time, and it's a potential source of liability. So you may not want to take that liability on when you're the acquirer, okay? So if you correctly structure an asset purchase agreement, it's possible to leave that liability behind. Mergers, as I said before, they can be great. They're a mechanism by which you can acquire all of the stock in a company, provided you get the requisite level of shareholder and board approval. But sometimes if it's a small deal, it's easy just to do a stock purchase agreement. And now, again, there are tax reasons associated with this, whether or not the consideration, the purchase price, which is what we're moving down, is stock. Maybe you'll be issuing stock in exchange for the shares in that company, or maybe you'll be paying cash. And there are reasons to do that. Who here has heard of an earnout before? I know some people have been involved. But an earnout is a mechanism by which, basically, if there's a difficulty in determining what the right price is for the company, okay? This is an attempt to solve that mechanism. So how could there be concern? Well, you as the CEO of the startup being sold, of the target, think, man, we have great prospects. Sure, we did 10 million this year, but next year we're going to do 50 million. And, our company should really be worth, 75 million, not the 35 million that the acquirer is offering. And the acquirer says, no, look, we've seen what you've done. You've done 10. You're only going to be able to do 20 next year. That said, we have faith in you, especially if we put our resources into this company. So we're going to make you this offer of 35 million. And earnout is a mechanism by which you can wait and see and kind of do a purchase price adjustment later on, okay? So that if those metrics are hit, they get earned. Other things that get negotiated is the drafting of the definitive agreement. Okay, who's going to handle that? Is it Target's counsel going to take the first stab at it? Is it the acquirer that will be taking the first stab at it? How will revisions be handled? All of this kind of stuff goes on. And people like to sort of think, well, if my lawyers don't do the drafting, it's going to be cheaper. And the answer is maybe not. The reason is that unless you have a really friendly acquirer, they're going to put all kinds of language in there that is going to be favorable to them, not favorable to you. And so your lawyer is going to have to read through that document very carefully and mark it up substantially. So it may not be any less expensive. What happens to key management and employees? Oftentimes, especially with acquihires, who here has heard of an acquihire? Right, that's when they're basically, an acquirer is primarily interested in the team as opposed to the intellectual property or the customers or anything else in the company. And even aside from that, the acquirer is going to want to make sure that certain folks remain in place, okay? Some folks are so critical to a company that if they're not there, at least for some period of time, then they're not getting what they paid for. So how those folks get handled, that should get involved, or you should at least be thinking about it through the letter of intent stage. The exclusivity period will get looked at. You should at least contemplate it in the letter of intent. Breakup fees, confidentiality, also boilerplate issues, right? Like which state law governs. Is it Delaware? Is it California? If there is an issue and it has to go to court, does it go to court or does it go to arbitration? All these things kind of get taken a look at in the letter of intent. You guys following me? Who's sleepy? It is warm in here. So let's move on to the due diligence process. And this is the opportunity or the point in time where the acquirer gets to take a look at basically everything that the company has done. They're going to want to do that. You as the target, you may be able to limit the scope, especially if it's like an asset deal and they're only taking certain assets. They don't need to be able to go through absolutely everything. So that's one thing that gets negotiated at the letter of intent stage. But in here, this is when they get to kind of take a look under the hood, make sure they're actually getting the real McCoy. So that's what they'll do. They'll come in. They'll take a look at all of your corporate books and records from the beginning, maybe even from before the beginning. Okay, and what do I mean when I say that? I mean, if you've been working with 4 friends on a startup and you never incorporated, or you incorporated later and one of those friends exited already before the company incorporated, they're going to want to know that. Okay, they're going to want to know, is this going to be a repeat of the social network? They're going to want to take a look at all of your financings. Okay, so Sometimes we have clients who have done some of their own financings, especially with convertible debt, before they hire us, and it can be a nightmare to clean up. And the acquirer is going to want to know that. One of the reasons is that they're going to need to get shareholder approval for this deal. Okay, and they're going to want to know that they get requisite shareholder approval for the deal, so they need to know who the world of shareholders are. Because if they don't know who that world is, they can't be assured that they're going to get that. IP. IP is so critical here in the Valley, right? So it may involve patent reviews. It may involve copyright reviews, trademark reviews, trade secret reviews. They're going to want to make sure, potentially, they're going to want to take a look at all of the intellectual property assignment agreements between either the consultants or contractors and the company, or the employees in the company. They want to make sure that everybody who worked on that code assigned whatever rights they had to the company, so that they can be assured that they're buying that IP and they're not buying a lawsuit. This takes a lot of time. I mean, this can take weeks or months to go through all of this. There are open source issues. Who here has ever heard of, I'm sure you've all heard of open source, right? What are some of the issues that go in with that? Okay. Open source is governed by open source licensing agreements. Some of those licensing agreements have terms that are not going to be so favorable in terms of maintaining the propriety of the code. Okay, some of them require that you publish certain things online. Maybe you don't want to disclose that. That's like a trade secret. There are acquirers who will require that your code gets audited. Okay, there are companies out there that will take a look through your code and look for open source to make sure that they don't have these segments which could infect your code and be a problem. There could be third-party license issues, right? Almost nobody completely builds their code from scratch. Either they use open source, or maybe they'll license certain content from, or certain software from other folks. They want to have all that taken, reviewed. Other things that get reviewed, right? The premises. Okay, let's say, we had a client that did manufactured certain parts for trucks. Okay, and it is not unreasonable for an acquirer to come in and take a look and make sure, are they using hazardous waste or hazardous material? We know that they say that they don't, but they want to come in and take a look at the premises. Are there certain the right safeguards in place, right? I mean, are folks using the masks to prevent them from inhaling dust, or are they not? In which case, in 20 years, you're going to have a whole bunch of claims by employees for lung issues, okay? And that's going to come out of nowhere. So they want to take a look at all this. Take a look at what their exposure is to risk for things that you probably don't even think about now, but this is what happens in the process. You guys following me? Sweet. All right. A super big one, which we mentioned earlier. Have you hired people as contractors or employees? Are they really contractors, or are they really employees? Where does that come up? Comes up not only because they could be, alleging claims for not being paid minimum wage, but also the IRS, the FTB, the California EDD, for payroll tax. They may come out of the woodwork and say, look, since you guys were paying them as contractors, you didn't collect the tax and pay it to us. Really, they should have been employees. You're going to owe us that tax. Nobody wants to wake up with that letter or that phone call. You don't want to walk into the office that day. Tax issues. Have you been paying your taxes? Are there 401k issues? Are there 409A issues? 409A, who's heard of 409A? Granting of stock options, okay? Whether or not they're done at fair market value can have a big effect, certainly on the employees, but acquirers want to know this as well. State sales tax. Should you have been collecting in the state of Wisconsin, where you were selling certain products? Okay. Maybe, maybe not. Depends. I mean, did you have a team there? Did you send somebody there? How often did you send that person there? Those are the kinds of things that get vetted in the due diligence process. So as you can see, it's pretty exhaustive and it takes a fair amount of time. One of the ways that we kind of work through this, and certainly at least in taking a look at all the, sorry, I'm going to try and stay in the same place. One of the reasons why one of the ways we work through this, especially when reviewing all the agreements, is we set up what's called a data room. Okay, it's basically like a Dropbox or maybe even a fancier Dropbox. There are companies that will host that. The target will put their documents in there, and then the acquirer can take a look through them. But before you just go ahead and post all of your documents in there, you want your lawyers to take a look at them to see if there's, problems, okay? Better to get ahead of the issue than to be caught flat-footed. Let's talk about the definitive agreement. This is that beast of an agreement that I was talking about before. So in all of these, there are just certain sort of standard parts, regardless of whether or not it's an asset purchase agreement or some sort of other deal. So, we'll talk about who the parties are, what the structure is, okay? Is it going to be an asset purchase agreement? Is it going to be a merger? Will they be setting up a merger subsidiary and doing like what's known as a reverse triangular merger or a forward triangular merger? That's good. I saw some eyes glaze over. But basically, how does this actually get accomplished? Okay, that gets handled in there. Reps and warranties, okay? Representations and warranties are basically statements of fact or representations by various folks in the company that certain things are true, and then they stand behind it and they warrant it. Okay, those are highly, highly, highly negotiated and can be very, very long. And it can go to things like, all of the intellectual property that was developed was assigned to the company, okay? So that's one reason why we take a really thorough look through all of the agreements between the consultants and the employees. It can be warranties, it can be reps and warranties on some of those other issues that we talked about before, like, we don't use any hazardous material in the manufacture of our product. And then of course there are just basic corporate reps and warranties, like we've indicated how our company is capitalized, that is who all the shareholders are. There's nobody else out there who's going to come out of the woodwork and claim ownership in this company. We have the requisite corporate authority to enter into this deal. We've taken the requisite, we've gotten the requisite board approval and shareholder approval to do this deal. All those things go in there, and they're highly negotiated because they're potential sources of liability later. Okay, it's about risk assessment and risk allocation. Who's going to be holding the bag if, in fact, that initial partner who didn't actually sign up with the company, but he comes out of the woodwork later and is claiming that, no, he actually has 25% of your company. Is it the acquirer who's going to be stuck defending that and paying for everything, or is it the company or the former shareholders? Covenants. What are covenants? Covenants are promises. So you're going to, frequently we'll see stuff in there like you'll conduct your business normally. Well, of course you would, right? Well, no. Sometimes you can be incentivized to try and, like, let's say there are different provisions that are put into the agreement so that you get more cash, if your sales are up, okay, by the time it closes, right? Well, they don't want you to go out there and just dump a whole bunch of product like on the market, knowing that it's going to get returned, okay? That's not cool. No shop clauses, that is, you're not going to shop this deal around to other companies, that'll probably be in there. Pre-closing actions, okay, and conditions of closing, maybe this is a little bit duplicative, but you're going to have agreements in the company. So this comes up in a couple different ways. There are agreements out there that frequently will require either notice or consent for those agreements to be assigned upon a merger or certain kinds of acquisitions. So for example, your lease, okay? Your landlord leased the premises to your company with you running it. So your landlord wants to know, well, who's going to be the next owner? Who's really going to be running this thing? So leases, that's frequently in there. Typically also in certain kinds of software licensing agreements, you'll have these assignment provisions. You got to make sure that you go out there and get those approvals. And if you can't, then you need to work with the acquirer to make sure that they're comfortable and they waive that condition to closing. Right, we talked about termination fees. Indemnity. Well, that's about, then this is highly, highly negotiated. That's about those reps and warranties. Who's going to be holding the bag after the deal closes? And are there going to be mechanisms by which the acquirer can get reimbursed? Okay, so sometimes there's an escrow afterwards. A portion of the deal consideration is going to go into escrow, and it'll be used to fund any breaches of reps and warranties. That is, Bob comes out of the woodwork, okay? And so basically the former shareholders are gonna have to pay for fixing the problem with Bob. And so as you can see, that's really highly, it's really highly negotiated because there's a lot at stake. And there are also other solutions and things that can get worked around in that. You can buy reps and warranties insurance, okay? But it's expensive. So I think one deal we worked on, it might have been $200,000 in order that was the premium for the insurance. And potentially, there are millions of dollars on the line, so it's important. Again, the other miscellaneous sort of boilerplate issues that go in there: choice of law, venue, where does this matter get litigated if there's a problem, and how do you handle attorney-client privilege? Okay, what does that mean? Well, that means basically, typically, the attorney-client privilege is controlled by the board, okay? And it vests in the company. When the company gets sold, it travels with the board. So you may have the board, but there are different board members on the board. And you don't necessarily want the person who acquired your company to know what all of your discussions were with your counsel and whether or not you would have paid more, or accepted a lower number, and whether or not you knew about some problem. And those issues need to get handled, and they're pretty important. So let's talk about, we're kind of running towards the end here. We got maybe 10 minutes. Process, pre-closing, closing, post-closing, and integration. So pre-closing, this is the period of time after there was first board approval for the deal, for the definitive agreement. The definitive agreement got signed. Typically, depending upon the type of deal that you do, there will probably need to be shareholder approval, okay? And then, this is one of the reasons sometimes why we choose Delaware over California, but one of the reasons why Delaware is good is the type of shareholder approval that you need to get, might be more favorable in Delaware. Dissenters' rights, that ties into, well, actually, I guess it certainly ties into mergers, okay? And that's a mechanism by which if shareholders, so before we talked about how you could force basically a sale of somebody's stock, even if they didn't approve of it, so long as you got a sufficient corporate vote or a sufficient vote. Law says, yeah, you can do that, but we're going to give those folks appraisal rights so that they have a mechanism so that if they're not, in fact, receiving fair value, they can get paid out for it. And so that's what dissenters' rights are. In this pre-closing period, we talked about notice and consent for assignment of contracts, other contingencies. Okay, maybe you need to make sure that you get the dust remediation hardware in place. We were talking about that earlier, like if you're a manufacturer and there's a lot of dust and you want to make sure that your employees aren't inhaling that and causing long-term problems. Maybe as a condition to closing, you got to get that in place, something along those lines. Depending if your deal is big enough, okay, and who it's with, you may need to get regulatory approval, either from the SEC or there are other approvals that need to be done. You make sure that there aren't antitrust issues. So that also comes up there. Closing, as I said, it's not just about champagne. This is when the actual execution and exchange of the final documents and certificates takes place. And then on those days, there'll be certain documents that get filed, with the states and potentially also the federal government as well. And then post-closing, there are certainly other filings that will need to be done. Potentially if there are securities that were issued, there'll have to be securities filings, either with the SEC and or the state or states. Completing of the notice and appraisal rights. And then integration. Who here knows what integration is? Yeah, that's when you now put these babies together and you're actually going to try and realize the value of all the work that you've done. And integration is really beyond the scope of this conversation tonight. But that's where these deals really win or lose, right? If you need to bring, and this is a business issue, but there needs to be a good transition team in place. And when you're exiting, you need to have a clear picture on how it is that you can realize the value of what you've built so that your acquirer can get the value of what they paid for it. Because, look, bottom line is that this and like many other things is about relationships, and you want to make sure that you have a good relationship with your acquirer, especially if you're going to be on board with them for 12 months, 24 months, or later. And it also is a reflection of, especially if you're a CEO, reflection of you and how you've done as a businessman. Did you successfully exit, or did you just dump the company at the last minute and you're going to earn a reputation moving forward? So with that in mind, let's move to what some of the common deal pitfalls are, and then we can take some questions and comments. So one real common pitfall is not negotiating your engagement agreement with your banker or your financial advisor. And typically they get compensated on contingency. They'll get 1 or 2% of the deal. They may ask for a retainer up front. And you may be able to negotiate that down. You may not need to pay them $50,000 or $100,000 up front to get them going. So pushing back on some of those things, pushing back on whether or not there are any exceptions to the exclusivity of the relationship, and how long it is that you'll be on the hook if, even though they've stopped working for you, a deal gets done. Those types of things are important to negotiate ahead of time. Failure to negotiate key terms in the letter of intent. Well, as I've said earlier, if you are the target, okay, you're never more attractive than before you sign that letter of intent. And the reason for that is sort of twofold. One, and primarily, is that, especially if there's an exclusivity provision in there, that's it, you're locked up. Or at least you're locked up for a long time. And then the other is the psychological anchor that gets set, okay? Everybody expects that letters of intent are going to be the main, or the substantial real terms in the deal. And if you kind of try and whip out another big deal breaker term later on in the negotiation, someone may just walk and say, no, look, you're not negotiating in good faith. So getting ahead of that and negotiating key terms is important because for those two reasons. And the other thing, too, is you need to take a step and take a look at it. Engaging in a merger or an acquisition takes a lot of your time and a lot of time of your team, okay? And if the deal's not going to work out, you're going to want to rip that Band-Aid off sooner rather than later so that you don't waste all the time and energy putting it into the deal. So better to figure out earlier whether or not you can move forward. Not having fully executed written engagement agreements or other agreements, either with your employees, with your consultants, with your shareholders, with your stockholders. That's kind of a duplicative of what I just said right there. But this exercise can be a tremendous paper chase and can cost a lot of money if you haven't taken care of those things right from the get-go. Because the acquirer is going to want to see all of that, or they're going to want you to pay to get it fixed so that they know what they're buying and they're not buying a lawsuit. In the same vein, not having adequate corporate books and records, and acting as your own legal counsel or hiring the wrong legal counsel. Basically, that sums up all the rest of them, okay? Because the issue is you don't want to miss something that's going to end up costing you a lot of money later on. And so you want to hire lawyers and bankers and accountants who know and who work in this particular area so that you can not fall into one of these pitfalls. So that's pretty much mergers and acquisitions in a nutshell. I hope you're still all awake. We'll take questions and comments, and Rob always requests that you speak into the microphone.
I'll be first. How can other countries get involved? Recently, WD, a couple years ago, said they wanted to buy HGST, but the Chinese government wouldn't allow it, or they allowed it partially. How can another government get involved?
Well, I mean, each state, whether it is at a state or state in both in terms of the U.S. state level or state in terms of using another country, using that term in both ways, sets its own rules and laws. And the government gets involved in many ways, okay? Sometimes, for example, in China and other countries, you can't have, more than a certain number of foreign shareholders. Okay, so there are laws that are out there, and they require that those requirements get met. Here in the U.S., obviously we allow foreign shareholders in companies so they can acquire U.S. companies, but there could be other reasons. So, for example, there can be antitrust reasons. Okay, and the Department of Justice will block or prevent a merger or acquisition from happening. And it doesn't have to even just be a merger and acquisition. It could be an other major deal. Okay, so for example, and this comes up very frequently, Google has a tremendous penetration into the search market. So whenever there are going to be potential deals relating to the search market, the Department of Justice is going to scrutinize that pretty carefully. And you see that all the time. You read about it. Google's the DOJ is looking into this matter of antitrust with regard to Google and other companies as well. Microsoft, obviously. So that's how different countries can get involved. Did that answer your question, John? Okay. Thanks. Anybody else?
I've recently had several companies of mine acquired, and the last one, the acquirers insisted upon setting aside funds for the life of the patents. How common is that? They considered them to be a living entity that could be prosecuted or litigated sometime in the future.
Well, I don't know what motivated those potential buyers, and I can't say that. I mean, we really always push really strongly to have some sort of end date for the escrow. So you're talking about basically they required you set aside funds, like escrow funds, basically indefinitely?
Yes, definitely for the life of the patent.
Oh, for the life of the patent? Yeah. Yeah. Well, I could see. I mean, ultimately, it comes down to risk allocation, and so they felt that they were paying a substantial premium for those assets, and that to the extent there was any risk, it should be allocated to your company, to the shareholders. And I guess it's a negotiation point, and whether or not you can live with that deal. It sounds like you could.
Do you see that as common? Is this typical?
I've not seen it done before, but I can't tell you what the metrics are on that. We would not. I think we push pretty strongly to not have that done, but because we normally like to see escrows kind of wound up between 18 and 24 months or so. And so normally we don't have these liabilities that could hang out there for 20 years? I mean, how many years were left on the life of the patent?
Approximately 12 years, but they wanted another 5 years beyond the longest existing patent.
Wow. Well, I mean, look, if there was a great deal and you were happy to take that risk, then that works. But it's not. I wouldn't call it common. Anyone else? Sure.
So I know that every client is different, but
Yep.
Is it possible to comment on a timeline? You have different phases that you described to us, and maybe which ones take the longest, and maybe a small company with 10 people.
Yeah.
What's the shortest it can be done, and what's the longest? It could be forever, but
Yeah.
maybe which ones take the longest and timeline, average times.
Yeah. So, I mean, I've seen them done as quickly as 2 weeks for small, unsophisticated companies, 2 or 3 weeks, but that's pretty uncommon. I would say you're normally looking at, probably at least sort of 6 weeks or longer, and then I've seen deals, and they say time is the enemy of deals. We're working on one where there was a lot of cleanup that had to be done, and we're 8 or 9 months in, and it's a relatively small company. Now, why is that? That's because the acquirer wants to make sure that the company gets cleaned up, and there was, a lot of corporate books and records, and it required, because it was a Delaware company, it required action, with the Delaware Secretary of State, which of course required first certain kinds of action and approval by shareholders, and it had, 20 or actually no, it had 40 or so shareholders, so trying to herd all of those cats can take a lot of time. In terms of the deal stage process, letter of intent, everyone wants to bang one out in one night, and you can certainly do that. But I think, I hope you've kind of seen from the content of my presentation, you want to make sure you're not missing any big action items. And so normally that requires at least one night to sleep on it. And it also is a negotiation, so it goes back and forth. So seeing a week or 2 weeks for a letter of intent is not unusual, and it can be longer. And it's better to take that extra time and do it right, especially because you are setting, as I said before, the expectations, the psychological anchor early on. And you're going to be spending a lot of time and effort after that. Okay, the diligence process can take weeks or months to move through, as well as while that's going on, the negotiation of the definitive agreement, that takes a certain amount of time as well. And then from closing, you can do a simultaneous sign and close if everything's pretty much all buttoned up. But it's not uncommon to see a month or so in between the two, especially if there are some real action items that have to get done. So. And then, of course, if there are other regulatory hurdles and stuff that needs to be taken care of in that window, that's going to extend it a little bit. Because Lord knows you can't move the government faster than it wants to move. So does that answer your question?
Yeah. Jason, so that was a great presentation.
Thank you.
What's the primary difference between a merger and acquisition from a startup perspective? Is there any special thing they need to watch out for one versus the other?
Yeah, no, that's a good question. So, look, either of those events, and when we talk about an acquisition here, we're in my mind, I'm thinking of sale of, substantially all the assets, or the main assets that are of value or that are basically driving the business. Okay, in that circumstance, in one respect there is no difference. Okay, it is an exit. Okay, it is potentially a liquidity event. In another sense, it is their choice between the two can vary substantially and can be varied for many reasons, including tax reasons. Okay, and liability reasons. So. For a merger, okay, that company is going to continue on in some form, okay? So the liabilities will continue on, but it'll have a new owner, okay? Versus if there's an acquisition, the company will remain with the same owners. So to the extent there was some sort of liability that was not, taken as part of the assets, if there's a liability that remains behind, you might be on the hook for it. So that's one issue. And then, of course, the tax implications of whether or not it's a cash deal or a stock deal are going to have some effect too. And for acquisitions, it could be a cash or a stock deal. For a merger, it could also be a cash or a stock deal. So it just sort of depends.
Can I get another question in?
Sure.
I think usually most private companies hope to be acquired by a public company to give them more liquidity. But sometimes a private company buys a private company. What are the differences or concerns there that you need to worry about?
Yeah. No, that is also a really great question. Okay, so one of the really nice things about public companies is that they are required to disclose tons of financial information, quarterly and then annually. Okay, so it's very easy to get information and data on that company. So if you're getting a stock deal from a public company, you know what it's worth, and there's those liquidity issues. The liquidity is there because you have a liquid market, a public market. One of the downsides, though, is you'll probably be locked up. You may not be able to sell that stock right away, but at least you have the data on the company. If you're selling to a private company, there are a few issues that come into play there. One of which is just information. Okay, it's harder to assess what the real value of that stock is. Like, sure, maybe they just did a Series C round, and they got valued at $2 billion or $3 billion. But does that mean that's really do you agree with that? I don't know. The other issue is, of course, the liquidity, which you brought up, which is that it's much harder to sell private shares of a private company. Now, there are some exchanges that are out there, and you may be able to do some of it, but it's much, much more difficult. So I think it's primarily liquidity drives it, and two, information. They're kind of related, but those are sort of the main issues there. Now, from a mechanical perspective, there are certain kinds of regulatory or exchange issues that come up when a public company is buying a private company and they're exchanging their stock and they're giving certain. What's that?
You got to be quiet. I mean, the public company can't announce.
Right, there are those issues as well as, you may need to get the approval of the SEC or the exchange as well. And then on the other side, if it is a private company buying another private company, that can really complicate the deal and it can make some other issues, right? So if you have unaccredited investors, and this is why, we always push to have accredited investors involved. But if you have unaccredited investors, there are certain information rights that need to go to those unaccredited investors unless they're getting cash. And so, the transactions costs associated with making sure they get the right kinds of financials and other information can be quite substantial. So that's maybe, obviously maybe not get you to choose between a public or a private company, but it's something to bear in mind, like if you're thinking about doing that kind of deal. Does that make sense? Sweet.
So I'm not, thanks for the presentation. I wasn't sure exactly where the banker comes into this picture.
Sure.
I understand all the other ones, but
Yeah. Well, I mean, they come in if the deal size warrants it, right? So if you're going to sell your company for, $100,000, it's probably not worth it. But, you start cranking up into the millions, and certainly tens of millions, they're going to add a lot of value. They're going to help you assess what the actual value of your company is, so that you're not selling yourself short. They're kind of like that real estate agent, and maybe not the best analogy, but they're kind of, they know the market, okay? Especially if you go to a banker who works on the kind of transactions that you're about to do. So they add value there. They will help you put in and put together, various kinds of information memoranda so that you can help sell yourself to the potential acquirer or acquirers. They'll help facilitate the data room and moving the data back and forth between the parties. Additionally, along the lines of assessing what the value of your company is, they'll go in and they'll take a look at, well, could you sell to somebody else? Could you do a private equity deal instead and get more money for it? Okay, because your job is to make sure you maximize the value to your shareholders, especially in a change of control event. That is, they're no longer, or the board, they're no longer in control. So if the deal size warrants it, you need to get bankers on board. Does that answer your question, Jeff? Or?
yeah. So when there's an offer, unsolicited buy offer, who's the first person do you go to help you get set up to?
Well, I would say me, but that was I appreciate that softball. No, I mean, look, I think. As I said before, I do think, especially if you have counsel and they're experienced in mergers and acquisitions, you want to go to your counsel first, okay? Because they'll help you figure out potentially even which banker to contact, and then help you also negotiate the engagement agreement with the banker, which can be 1 or 2% of the deal, right? So like let's say you're doing a $200 million deal, 1% is $2 million. So that's a lot of money to your shareholders. It's a lot of money potentially to you, especially, it also depends on especially on the margins, right? So, if you've been financed by venture capitalists, they're going to have certain kinds of preferences built into their stock. So they may see money way before any of the common shareholders do. So that $2 million could make a big difference between, the common shareholders like your employees or yourself walking away with full pockets or less full pockets.
Okay.
So, sweet.
Thanks for the presentation. So what's the worst that can happen if you start negotiating a deal and it breaks apart in terms of disclosing information and so forth?
Yeah.
Can you give an example?
Sure. I mean, there are many bad things that can happen. So let's take it from this perspective. One of the worst things that can happen is you can inadvertently enter into a binding letter of intent. Okay, and what will happen is you want to break up and you want to walk away, or maybe the buyer will want to walk away, and they will say, no, we don't want you to walk, and then they'll take you to court and they'll drag you through court, and you may be forced to do the deal based off of only that letter of intent. okay, and which doesn't spell out how all of these other issues, the sort of really thick slides, are handled. And that would be a tragedy. In terms of some of the other real problems, right, you don't want information leaking out that would be, deter your suppliers from continuing to supply to you or your customers from continuing to supply or continue to buy from you. It might be a situation where you're in a business where they're like, well, if we don't know if they're going to be around tomorrow, why are we going to order from them? And all of a sudden, you've lost your position in the market. So there can be some real consequences for breakups, especially if, one, there's not a mechanism to break up and people are fighting over whether or not it breaks up, and two, if there is information that gets out there that would damage your business. Does that make sense? I mean, and it's not just customers. I mean, it could also keep you from, there might be a perception that you're in a position of weakness, and then people won't, you won't be able to get the next round of financing, or if you do, it'll be a down round. And so, I mean, all of these things matter, if that makes sense. Right.
Last chance. All right, well, let's hear it, Jason.
So,
If you want the slides, just email Jason directly. His email address is up there. The video will be on our YouTube channel in about 3 weeks, youtube.com/IdeaIPO. Thanks for coming.
thanks. So, thank you all. Thank you for coming. And as Rob said, if you want the slides, shoot me an email, and I'm happy to chat with anyone after this. And if you guys are interested in continuing a conversation or setting up a time to speak to see if we'd be a good fit for something, shoot me an email. Thanks a lot. Yeah, thank you.